Hi, I'm Jen Lehman, co-founder of Property Elite, chartered surveyor and APC assessor. At Property Elite, we provide training and support for the APC, AssocRICS and FRICS qualifications. We cover all routes, pathways and geographic regions via our team of specialist consultants and trained assessors. This also includes the senior professional, specialist, academic and direct entry routes. In this week's podcast, I take a look at the legal case of Hart v. Large. This is of relevance to all APC and AssocRICS candidates, particularly if you're involved in any aspect of residential surveying or delivering home surveys to consumers. Head to our website blog and you can read the full judgment from the Court of Appeal. This dismissed the appeal and upheld the High Court's judgment. The High Court case related to a dispute between the purchasers, Mr. and Mrs. Hart, and their surveyor, Mr. Large. Mr. Large had been instructed to provide a Level 2 home buyer report on a newly refurbished property in Devon. Mr. Large's report focused on minor issues relating to drainage, gutters and pipework. The property was valued at £1.2 million, and Mr. and Mrs. Hart proceeded to purchase the property at this figure. Following the purchase, Mr. and Mrs. Hart experienced problems relating to water ingress and damp. They initiated a negligence claim against Mr. Large, as well as claiming against the conveyancing solicitors and the architect who dealt with the refurbishment works on behalf of the previous owner. The High Court held that Mr. Large was negligent because his inspection and report failed to identify the significant issues relating to damp. It was also held that he failed to advise both within his report and during subsequent correspondence to advise that Mr. and Mrs. Hart obtained a Professional Consultant Certificate, PCC, prior to purchase. The normal rule of applying damages was established in the case of Watts v. Morrow. This provides for damages to be assessed on the difference between the surveyor's valuation and the value of the property in its actual condition. However, in Hart v. Large, the court diverged from the normal position, and the award for damages in favour of Mr. and Mrs. Hart was assessed as being £750,000, taking into account a relatively high sum of £15,000 for inconvenience and distress. This was reduced to £374,000, taking into account out-of-court settlements with the conveyancing solicitors and architect. So what happened in the appeal? The appeal focused only on the damages applied by the High Court. Mr. Large, the surveyor, argued that the damages should have been assessed on the basis of the difference between his valuation and the value of the property with the defects that could have been identified but which were missed. This was based on the argument that the damages should not reflect the costs of repair unless Mr. Large had provided a warranty as to the condition of the property, which he did not. The Court of Appeal held that Mr. Large was negligent in his advice relating to the damp and damp proofing. In this case, Mr. Large should have followed the trail in relation to the evidence of poor workmanship observed and lack of visible damp proofing where it should have been observed, leading to a recommendation of further investigations being carried out. In particular, the new RICS Home Survey Standard states that an RICS member must recommend further investigations if they have a suspicion that a visible defect may affect other concealed building elements. Mr. Large was also found negligent in failing to advise obtaining a PCC prior to purchase, which would have provided Mr. and Mrs. Large with protection against concealed defects. If Mr. Large had have recommended obtaining a PCC, then Mr. and Mrs. Hart would not have proceeded to purchase the property. Mr. Large should have investigated sufficiently to give rise to a trail of suspicion which, taken together with the need for a PCC, which would have covered all aspects of the rebuilding works in any event, ought in turn to have led him to give very different advice. As a result of these events, the Court of Appeal held that Mr. Large should bear the consequences of such advice not having been given. This upheld the High Court's decision in relation to the measure of loss, which was unusual in a case of this nature. This was because the conventional method in Watts and Morrow would only have compensated Mr. and Mrs. Hart for the simple defects that were missed by Mr. Large. So what precedent did this case set? The Court of Appeal's judgment turned on the unusual facts of the case and does not represent a departure from the conventional position relating to the measure of loss in negligence claims against surveyors. In this case, it was the missed defects, failure to advise further investigations, and lack of advice to obtain a PCC that led to the court assessing damages on a much broader basis. So what does this mean for surveyors? Hart v. Large really does emphasise the importance for surveyors of being clear and advising clients on the survey level and scope of inspection, limitations and caveats. It also emphasises the importance of recommending justifiable further investigation and to consider whether any new information provided after inspecting or reporting affects the surveyor's original advice, and then updating their advice if it's justified to do so. Residential surveyors should ensure that they are familiar with the new RICS Home Survey standard. You can find out more by heading to our blog and looking at one of our blog articles on this. The RICS have also confirmed that they'll be publishing supplementary content to support surveyors in light of the Hart and Large decision. That's it for today's podcast. Remember, you can book in your free 15-minute consultation via our website. We can also provide feedback on your referral or prelim review report. If you head to our website, you can also access our other free support resources, including our ebook guides, podcast, videos, quizzes, blog, and CPD newsletter. We can't wait to work with you, so thank you for listening, and I'll see you next week.